Folks, hi there, Ben Beadle, Chief Executive of the National Residential Landlords Association here. Hope you're doing well. I'm here at the Supreme Court today. We are intervening in the case of Rakusin, and you may well have seen some PR around this. This case concerns rent-to-rent going wrong, and you may wonder why we are getting involved in things such as this. And I'm going to explain, because I think it's really important. Rent-to-rent, firstly, done right, works. Rent-to-rent done badly does not, and that's why we're outside here today. What happened in this case is that the landlord appointed a rent-to-rent provider because they were overseas. People like Mr. Rakusin appoint a rent-to-rent provider to basically take the hassle or the perceived hassle out of renting. Rent collection, repairs, maintenance, all of that sort of jazz. And of course, if the tenants change in between, you haven't got to worry about voids. The rent continues to be paid. Rent-to-rent providers obviously make their money on the difference between what they're paying the landlord and what they manage to get in the open market. Now, what happened here was essentially the rent-to-rent provider created a HMO that needed to be licensed. It wasn't licensed. There were a number of repairs that weren't done, and it all ended rather unpleasantly. The tenants sought to take a rent repayment order out on Mr. Rakusin. The first-tier tribunal, as I understand it, agreed with them. The Court of Appeal, when it went there, disagreed, and that's why we are at the Supreme Court today. We've intervened in this case to protect the responsible landlords, but also to protect the unwitting landlords who may well find themselves in a rent-to-rent operation and not know about it. And this is where effectively unscrupulous tenants take on a tenancy and then illegally sublet. And it's important to us, I think, that the court knows this nuance, that knows the background as to why landlords might choose this route, and simply poses the question about whether or not it is fair that somebody in either of those situations who have set out to comply, to do things right, gets landed with a rent repayment order based on the rent that the rent-to-rent operator was getting. That to me doesn't sound like cricket, and that's why we've asked David Smith of JMW Solicitors to intervene on landlords' behalf. It's being heard today, the 26th of January. We're not expecting a decision until much later in the year, but it's really important to me that the voice of the responsible landlord is conveyed at the highest level, and we'll see what happens.